Well, I'm here to talk about intellectual property and kind of relate various intellectual properties and entities to the various stages of the product development process. Adam gave us a wonderful overview description, detailed overview description of the product development process. Michael's kind of related crowdfunding activities of the product development process. And I'm going to relate various intellectual properties also to the product development process. And I'm going to spend quite a few minutes on the provisional patent application because under our current first to file regimen, the provisional patent application is one of the best tools that we have for locking in an early priority date for your product and the invention underlying your product. I don't have any slides in here. Okay. So just to reiterate, focused product design, just at a very high level, characterizes the product design process as consisting of research and ideation, industrial design, and then manufacturing. In phase one, that's your research and ideation. Your intellectual property activities are going to be, you don't really actually have a product at this point. At the beginning, at the outset of this process, you really don't have a product. You've got a raw idea, possibly not even an invention. And so at this point, your intellectual property activities are probably going to be more brand focused than they're going to be product focused. And a lot of these are sort of what I like to call quasi-intellectual property because they function a lot like intellectual property, even though they're not intellectual property, and they provide a lot of the same benefits. And you might be thinking about registering your business name, entity formation, securing those URLs and those domain names, establishing your social media accounts and working on your social media presence, and trademark registration. At this point, a good thing to be thinking about in terms of trademarks is registering your company name and your logo. Then trade secrets are kind of important here because you're going to be talking to investors and vendors and consultants, and those conversations should be secured with well-executed non-disclosure agreements. Okay, phase two. That's your, this is your prototyping phase. And at this stage, you're going to be thinking about the provisional patent application. This is actually perhaps the latest point during the product development stage that you should be thinking about the provisional patent application. Now, I love the provisional patent application because it accomplishes so much for so little. Now, as we've already said, the United States has shifted to a first-to-file system for determining priority of invention. And the effect of that is that it has made it all that much more important to secure the earliest priority date possible for your product. Now the way, yes?
So if you maintain a diary and you have a date, it doesn't matter?
Pardon me?
If you keep a diary and you have
It doesn't matter anymore. It doesn't matter anymore. It used to matter, but it doesn't anymore. Under the old first to invent regimen, those kind of records were crucial in actually proving that you were the first to invent. But it doesn't matter anymore. Under the first to file regimen, the person who wins the race to the patent office is considered the rightful inventor. And they are the one considered to actually be properly entitled to the patent. So, and now at this stage, and the provisional patent application is such a great tool because it accomplishes so much for so little. As we said, an early priority date is really important, and the way that you establish an early priority date is by filing a patent application. But filing a utility application is an arduous process. It's a very labor-intensive and a very capital-intensive process, and it's something that you might not really want to be devoting resources to at this stage of your product development process. And the law actually provides a remedy for that in the provisional patent application. It has the advantages of establishing that early priority date. It's an easy document to prepare. It costs a lot less to prepare than a utility application, and the filing expenses are much lower, and it accomplishes the same thing as the utility application. It comes with one catch, though. In the legal profession, we call a document like a provisional patent application a placeholder. It actually establishes a right, but in order to perfect the right, you actually have to follow through with another filing or another action. And in this case, in order to secure your priority right, you actually have to follow that provisional patent application ultimately within 1 year with the filing of a utility application. But in the meantime, filing that provisional patent application buys you an entire year before you have to incur that effort and that expense. And that's 1 year that you can use for refining your design, testing it in the marketplace, and also investing at this point in a provisional patent application has the effect also of reducing the cost of preparing your utility application, because all of the work that went into the provisional can actually be used to prepare the utility application. All the information, the drawings, can be repurposed and used in the utility application. Yes? If you don't make the 12 months deadline, well, it's not horrible. If you don't make the 12 months deadline, you actually lose the priority date. So that's not a good thing. But that's the only thing that happens. So you could actually start over and establish another priority date by filing another provisional application. And you haven't lost anything in terms of confidentiality because the provisional patent application is maintained in secret. It's never published or made public in any way.
So if you reestablish or refile the provisional,
Yes.
can you still claim the original date?
No, you can't. You would have to start over. You've lost that date. You've lost that date. So the provisional application provides you a lot of advantages for minimal investment of effort and time. And then also at this phase, you might be considering trademark registrations, but now you're going to be more product focused. So you might be thinking of trademark registrations for product names and brands and taglines and that sort of thing. Copyright might come into play here, because you might want to register the copyright on your source code, on white papers and other publications that you've prepared. Open source activities may be important. If you decide that you're going to incorporate open source technology with proprietary technology, it's very important to select the proper open source license under which you take that open source code, open source technology. Yes?
So suppose I file a provisional.
Yes?
And then you publish the whole law.
Mm-hmm.
On the trademark law.
Mm-hmm.
Does it give me a better protection?
How do you mean?
So I file my provisional date and that gives me the priority date.
Yes.
Then whatever stuff I have,
Mm-hmm.
publish it on the trademark law.
Mm-hmm.
So that way, once you publish, nobody else can file.
That's correct. That's correct. But also, well, by actually filing your provisional application, you've also protected yourself from incurring any kind of statutory bars as a result of your publishing everything on the internet. Because under the law, if you make your invention public, and then you don't actually file a patent application on that invention within 1 year, you've lost the right to file a patent application. But you've already filed it because you have a provisional application on file. So that's another advantage of your provisional application. Okay, let's go. Let's move on to the next one. Great. We're done.